Good morning, everyone, and welcome to our discussion of international humanitarian law and crisis. This is the seventh in a series of programs on international humanitarian law sponsored by the Lieber Society of the American Society of International Law. We'd like to thank the American Society of International Law and the DC Bar. We are privileged to have with us several experts on international humanitarian law today. First, Omar Shakir, the Israel and Palestine Director, Middle East and North African Division of Human Rights Watch. Next, Christian Jorgensen, who is legal counsel on international humanitarian law at the American Red Cross National Headquarters in Washington, D.C. And then Ido Rosenzweig, director of the Minerva Center for the Rule of Law under Extreme Conditions, and a professor at or affiliated with Haifa University. I think I made that mistake last time, Ido. And we may also be joined by an additional panelist whom I will introduce later. So we'd like to begin with opening remarks. Omar, please go ahead.
Thank you, and thank you all for joining. Really great to have this forum to discuss these issues, and I look forward to the discussion. Maybe I'll just say preliminarily, Human Rights Watch, since the last time we convened, I think released a couple of significant reports that bear on some legal questions that we've been discussing, as well as our factual documentation. And it's also going to be relevant to our discussion a bit later about some of the comments by President Trump. Human Rights Watch found in a November report, we looked at the system of military evacuation orders in Gaza. And the nature of displacement there, as well as the extent of destruction. As most listeners will know, the majority of homes, of schools, all universities, the majority of health facilities have been damaged or destroyed in Gaza, much of it from Israeli airstrikes. And Israel had most of the population of Gaza, virtually all, in fact, have been displaced, many multiple times over. So we looked at the relevant international law here to see whether or not this amounts to forcible transfer. And our conclusion was indeed that it was forced displacement, that the system of military evacuation orders, met that criteria, and that it's been widespread, systematic, and part of a state policy. So we concluded ultimately that forcible transfer, the war crime forcible transfer and the crime against humanity of forced displacement had been carried out in Gaza. And in fact, we also found ethnic cleansing, which, while not a legal term referenced in a treaty or a charter, of course, has been defined by, I think it's a report from the former Yugoslavia that described that policy. I'm happy to say more in the question and answer, but we also found that Israel's policy, specifically in the buffer zones, that's the area within a kilometer of the border, amounted to a policy of ethnic cleansing. And again, this will all bear, I think, in our discussion of the Trump plan, because this is our finding vis-a-vis what's happening during the active hostilities, as opposed to projecting forward. We also reached a very important report we released in December. That report was focused on access to water in Gaza. And our conclusion there was that Israeli authorities have deliberately deprived people of adequate water needed for survival. And this comes in several forms. That's restricting piped water, cutting electricity, and restricting fuel that's necessary to run water and sanitation infrastructure. Think of pumps, think of disposal of waste. There was also what we documented of Israel taking over control of areas and raising water infrastructure, destroying warehouses, attacking sanitation workers, blocking the entry of repairs. And our conclusion was that this amounted to the crime against humanity of extermination, as well as acts of genocide. And that basically that the Israeli government had created conditions, inflicted conditions of life calculated to bring about the destruction of the group in whole or in part. Folks will know that Amnesty International released a conclusion that Israeli authorities have also committed the crime of genocide. I should note that obviously we have a ceasefire in place now, and we've seen the release of hostages. Obviously, holding of hostages is a very grave violation, a war crime, violation of international law. civilians held hostage should be immediately and unconditionally released. We've seen the release of Palestinians, including some unlawfully detained, as Human Rights Watch has documented. We've seen an influx in aid entering Gaza, which has been significant. However, our overarching point is actually, given especially this last report we issued about water and electricity, people are continuing to die because ultimately what's needed is for the Israeli government to facilitate the rebuilding of the water and sanitation infrastructure. There's a need for, obviously not only the aid to continue, but there's also a need for kind of rebuilding of this critical infrastructure and ensuring that basic services are restored. So although we're in a period of ceasefire, fragile as it is, facts could change as soon as tomorrow, although it seems likely to continue longer. The underlying abuses have continued, and ceasefire not, people will continue to die unless, we continue. IHL obligations are not contingent on, agreement by states. They should be accomplished anytime. So civilians hostages should be released. Unlawfully detained Palestinians should be released. Aid should be allowed in at scale. Infrastructure should be allowed to be rebuilt. But we also must ensure accountability. I know we'll talk about the ICC and ICJ later. We can't let grave crimes, go unaccounted for, and we must address root causes, including the Israeli government's crimes against humanity, of apartheid and persecution against Palestinians. I'll stop here, and I look forward to a vigorous and conversation.
Thank you, Omar. Those were packed remarks, certainly. Christian.
Hello, everyone. Thank you for inviting me to participate. I'm going to try to keep my comments as brief as I can to avoid repeating too much of what Omar said. But two urgent legal and humanitarian challenges for me that I've been watching have intensified in recent weeks. This is the shifting perception of humanitarian workers and the broader implications of involuntary resettlement as a response to the conflict or an attempt to stop the conflict, which I'll speak about in greater detail in a moment. But both issues challenge longstanding protections under IHL and raise questions about the future of humanitarian action and civilian rights in times of war. Humanitarian workers operate under a clear mandate in IHL to deliver aid, provide medical care, ensure the protection of civilians without political interference. And this is even in the sense of conflict zones. Yet they are increasingly becoming viewed not as neutral actors, but as extensions of political or military agendas. Though IHL explicitly protects their ability to operate in conflict zones, this shift in perception has led to obstruction, restricted access, and in some cases, outright targeting of humanitarian efforts. The law provides a clear framework for them to serve civilians impartially and alleviate suffering, but their ability to do so is now being tested. I personally have been in situations where at the same event, I witnessed people accusing humanitarian workers of favoring one side, only for others at the same event to claim they are being biased toward the opposite. For me, it's a bizarre contradiction, but it's becoming more and more common. These accusations often stem, in my opinion, from a misunderstanding of what neutrality and impartiality, which are principles for which humanitarian organizations work under, and what they actually mean. Neutrality does not mean staying silent, nor does it imply treating all actions in a conflict as equal. It means working solely to protect and assist civilians no matter who they are, and doing so to the best of your abilities. Yet when neutrality is distorted or politicized, humanitarian space shrinks, and those in greatest need of protection suffer the most. So if this erosion continues, the consequences could be devastating, not just for this conflict, but for the ability to deliver aid in any future crisis. The second point that I would like to talk about is the framing of resettlement as a post-conflict solution, because it raises a lot of complex legal and humanitarian concerns. So under IHL, civilians cannot be forcibly removed from their land in any effort to relocate populations without their consent and without the approval of receiving states challenges the fundamental principles of civilian protection. And also it delves into a lot of other areas of international law. Resettlement is often framed as a practical measure in some cases, but when imposed rather than voluntary, it ceases to be a humanitarian response and becomes an act of forced displacement with profound long-term consequences. The consequences of such a process are not theoretical, they're deeply human. Resettlement is not merely about physically moving people, it's about their ability to rebuild lives, retain legal protections, and secure long-term stability. Without guarantees of citizenship, economic inclusion, or security, displaced populations face statelessness, economic hardship, and permanent displacement. Likewise, receiving states may face their own resource constraints and political pressures, adding to the instability of the region. The true measure of whether resettlement is a viable solution is not in the act of relocation itself, but in what follows, whether those affected have legal protections, agency, and the ability to rebuild. So throughout this conflict, my fear of growing disregard for the law has also increased. In the past, violations of IHL were often met with attempts of justification. So could be legal arguments, strategic reasoning, or at least the recognition that certain actions required a defense. Now I am witnessing an openness to disregard legal protections altogether without an attempt at justification. There is an increasing normalization of rhetoric that treats fundamental principles as optional or even as obstacles to strategic goals. So if this trend continues, it risks undermining not just compliance in this conflict, but the entire legal framework that governs war. So all of these issues, the rejection of humanitarian neutrality and the oversimplification of resettlement as a solution, threaten the integrity of international protections designed to safeguard civilians. And that's the focus of what the Red Cross is really focused on, is protecting civilians and alleviating suffering. The decisions made today will not only determine the outcome of this conflict, but set precedents, in my opinion, for how humanitarian actors and displaced populations are treated in conflicts to come. The law already provides clear safeguards for both of them, the protection of aid workers and the rights of civilians to remain on their land. Ensuring compliance with these protections is not just about this moment, it is about preserving the humanitarian and legal frameworks that uphold civilians' rights in war. So I look forward to the discussion, and I'll speak as much to all the points that are raised. And I just wanted to add that any opinions that I voice are my own personal views and opinions, and not that of the organization I represent or the Red Cross, Red Crescent movement as a whole. I just wanted to add that.
Thank you very much, Christian. Ido.
Thank you. Thank you very much. I want to start with to thank the ACL, the Libre Society, the DC Bar, and the organizers, especially Taylor and James, who are always in the background, but they are still there and very helpful, for the whole support in this series of webinars. I think that by now I can say that I'm a veteran in this series of talks, and we've done so many of them throughout the last year or so. And I think I've said before, and I will say it again, this webinar, this specific event has some kind of a special nature where it allows us to clearly disagree on a lot of issues, but we do it in a very civil and interesting way, and the discussions are very interesting. So I do believe that this is going to stay the same for this session as well. I want to start my introductory comments by saying that right now we are addressing some kind of chaos that we are trying to work within. I think what I care about the most right now is the fact that we are in the middle of the world's worst reality show called The Hostages, in which we wait to see on each and every week which 3 hostages are going to be released by terrorist groups, Hamas and Palestinian Islamic Jihad. And we've seen just last week in what conditions they are being held, how they returned, the horrific situation that they have suffered. And if this is not enough indication of the treatment that they receive in captivity, let alone those who are still there, and the testimonies that we've heard from them so far about the inhumane and cruel treatment that they receive, we also seen the subhumane treatment during the ceremonies, and I can't even call them ceremonies would be the most appropriate way to refer that. And this is really a sickening situation. I watched last week's exchange or release of hostages, and when I heard Eli Sharabi talking about the fact that when he was interviewed by his tormentor and was asked, "What are you looking for?" and he said, "I'm looking forward to meet my wife and daughters." When everybody knows, everyone except Eli Sharabi knew that his wife and daughters were killed on October 7th. You just can't manage, you can't handle the situation. And this is another layer of the torture, of the inhuman treatment that these hostages have received for the last 15 months, and it is still going on. And the fact that we are waiting to see if there are going to be released 3 hostages tomorrow and another 3 next week. And in 2 weeks from now, they're finally probably going to release Avera Mengistu and Hisham Said, who have been held in Gaza for more than a decade. Then we have to understand that this is the situation that we are dealing with. We are dealing with the worst of human beings, and it has implications on the situation on the ground. And in the past, I've heard several comments, mainly from Israeli either journalists or politicians, referring to Hamas members or another terrorists as animals or inhumane or non-human and something like that. And generally, I'm opposing such a language, because I think this prevents us from recognizing the limits or the lack of limits of human cruelty. And this is where I actually take this into situations of international law, of the future of the Gaza Strip, of situations of armed conflict. And I think that if this is the way Hamas treats people, and we know how Hamas treats local Gazans, Palestinians in Gaza on a regular basis, I think that I find it hard, I honestly find it hard or difficult to understand how human rights activists can be so eager to let and lobby and advocate for the ruling of Hamas over the Gaza Strip, just by, well, let Israel out and let Hamas rule. I think they can compare it very much to the situation of Taliban in Afghanistan. The US went out, Taliban to control, Al-Qaeda and Taliban basically to control over Afghanistan. And we've seen the situation of women's rights in Afghanistan. We've seen the situation of human rights in Afghanistan. And I don't think it's a binary game. I don't think it's saying that either Israel control Gaza or Hamas control Gaza. There has to be a better solution. And it can't be that this is what they want and this is what we're going to get, because I find it hard to believe that anyone would want to actually live under such conditions. I don't think that anyone should advocate for such conditions. And this brings me actually to briefly to the Trump plan of evacuating the Gaza Strip. I think that there's been way too much discussion about this plan. Too many people have written about it. Too many people have spoken about it. This plan is not reasonable. It will not happen. It will not happen because it's not plausible, and because it's illegal. We are talking about what seems to be ethnic cleansing, which seems to be illegal transport of people. I don't think that this has any chance to play any role. We need to look at it as what it is, as a play within the negotiations. And as such, we need to address it accordingly. I mean, in the last week, we've heard Trump talking about his plan. Hamas talks about stopping the release of hostages. Israel claims that Hamas has to release 9 hostages or all of them or whatever. And eventually we return exactly to the point we've been a week ago, where tomorrow 3 hostages are to be released. So that entire week has been one big game, basically, of negotiations. And this is a spin that has caused so many human rights activists, so many international law experts to just jump and say, well, this is either good or bad, false, etc. But with regard to actual practical implementation, it has zero meaning. I want to address two small points that has already been mentioned by Omar. One is the notion of forced displacement and human rights conclusion that it is a crimes against humanity, etc. Well, for once, in order to have crimes against humanity, you need to prove some kind of mens rea, and Israel at no point actually said formally that there is any plan other than to evacuate civilians as a precautionary measure from the area of hostilities. And seriously, they are actually returning to the north right now. So to claim right now that there was forced displacement, where Israel said that it was temporary, and right now people are returning back north, then I think it's jumping to conclusion, much as has been done several times in the back and throughout the year. I mean, when you have two alternative interpretations to the situation, one, to look at it as part of precautions, and the other one, to look at it as forced displacement, to jump necessarily to the forced displacement without having all the information at hand, without having the intention of the actors available, I think this causes only damage to any claim that international law is applicable to the situation. International law should be analyzed in a non-biased way to the situation. We have to wait and see what are the actual facts on the ground. And with regard to the water, etc., and sanitation, etc., I think this entire claim is based on the notion that Israel is still an occupying force since 1967, basically, in the Gaza Strip. And I think that my perspective is that the occupation ended with the Israeli disengagement in 2005, and therefore there was no such obligation between 2005 and 2023 or 2024. What is the current situation and the current level of control that Israel has over the area is an interesting discussion that should be held and could lead to some levels of discussions about what should and shouldn't be Israel's responsibility over the area. I think we cannot get into that discussion from the assumption that the Gaza Strip was occupied in October 2023 and until this day. This is an issue that has a question mark to it, definitely. I will finish completely my introduction words by saying that I think generally speaking, and you mentioned, Marianne, you mentioned Ukraine, and we've talked about Israel and the other situation. International law in general right now is at crosspoint that has several forces that cause that. And we've seen similar crosspoints in history, and every time that it has led to some change in international law. I don't know, and I can't foresee what will be the change in this current situation, when I'm actually very eager to look at it and explore it and research it in order to understand it better. Thank you.
Ido, thank you very much. I have a number of questions. We have some great questions in the Q&A, which I want to get to as soon as possible. But first, just for clarification purposes, Christian, maybe you can speak to this. And since Ido's mentioned the hostage situation, the International Committee of the Red Cross has been prominently, their logo has been prominently displayed during the release of the hostages because they have, in fact, provided transportation out of Gaza for a number of the hostages. Do you want to comment on, going back to your point about neutrality and impartiality, the role the ICRC has played in the release of the hostages?
Yeah, so the ICRC has a mandate to be a neutral intermediary between the parties in a conflict. So they'll help facilitate the transfer of those individuals. And when granted access, they'll check on the conditions of those individuals. We also have to understand that the ICRC is not, they can't just force themselves in. That's not how this necessarily works. And I think at times people think they can and they can't. That doesn't mean, and also I want to make clear, because there was a question in the Q&A that I was just typing an answer to. My comments earlier, I think it's totally appropriate to scrutinize any organization. I think that's totally fine. And I think that's necessary because that helps with transparency and everything. However, you can't necessarily judge the actions of an individual for an entire organization's mission or core mission exactly. So that's the role of the ICRC when it comes to the hostages. They're the lawful neutral intermediary that's providing the transfers and being used by both parties in that humanitarian sense.
Thank you very much, Christian. Just a quick reminder to all our attendees that if you want to pose a question, don't raise your hand. Actually type it into the Q&A so that I can read it. Before we get to the audience questions, I wanted to go back to Omar for a moment. And you referenced the ICT, the fact that ethnic cleansing is not codified by a treaty as a crime against humanity, but it has been characterized as such by the ICTY, that is the International Criminal Tribunal for the former Yugoslavia. Is that correct? Do you want to speak to that?
Yeah, sorry, I misstated because I was, it's by the Commission of Experts. So it's not a formal legal term recognized under international law, but the final report of the UN Commission of Experts on the former Yugoslavia described it basically as a purposeful policy by an ethnic or religious group to remove by violent and terror-inspiring means the civilian population of another ethnic or religious group from certain geographic areas. So that's sort of the reference point here. So we use it in our report specifically to talk about the policy in the buffer zones, where basically almost all signs of life, and this is tens of thousands of Palestinians lived in these areas, have been removed. Marianne, if you would, can I respond kind of briefly to a couple of points that Ido made? Is this the right time to do so? So yeah, and I enjoy these conversations because they allow for really substantive back and forth on the topics, and I agree actually with a number of points Ido made. What I will say though is in terms of his responses to my report, the fact that Palestinians are being allowed to return to northern Gaza doesn't mean that Israel didn't commit a crime. First of all, as a general legal point, right? Because an act stopped at some point in the future doesn't negate the intent existing in the future, right? But that's besides the point, right? The main point here is that Israel has deliberately made northern Gaza unlivable, and that's sort of what our research and documentation shows. Let me take a step back. The law of armed conflict applicable in occupied territory permit displacement only exceptionally for imperative military reasons or for the population's security. Our research shows that there was no military imperative to displacing basically the entire population of Gaza. There's no plausible way you could displace the entire population and meet that narrow test. And not only that, even if you grant that Israel was able to do that, and again, the report is very detailed, I don't have time in this to go into it, but the evacuation system severely harmed the population, often spread fear and anxiety. And even in areas where people were displaced to, Israeli forces repeatedly struck safe zones, evacuation results, etc. Right? And so Israel has left large swaths of Gaza uninhabitable. They've intentionally demolished civilian infrastructure in areas where they had complete control. Forget the context of hostilities. They took areas, they did controlled demolitions, including in the buffer zone area. They've, ruined the water and electricity infrastructure. Gaza is unlivable today. I mean, even President Trump has acknowledged that part when the majority of homes and infrastructure has been there. When you make an area unlivable, that is very relevant. And again, Israeli authorities' statements, I'm not going to repeat, from the early days of October 7th, set very clearly this policy policy that's been followed by their action, especially the deliberate ones. And just on water and this point that Israel wasn't, and we know we've talked about this in previous sessions, we can have a debate about whether or not Israel is the occupying power before October 7th, right? I mean, the ICRC, the UN, we've all said by virtue of Israel's effective control, for years they've controlled the airspace, the movement of people in and out, the buffer zone, the VAT, so many, the infrastructure, the water, the electricity that comes in. But putting that all aside, there is no argument that Israel's had effective control over Gaza since October 7th. I mean, there's no one with a straight face when they're forcing people out, their control of areas. I mean, I don't think there's any plausible argument. And when it comes to water, we're talking about stopping piped water, destroying infrastructure, blocking repairs, blocking electricity, not letting fuel in. So I have a very difficult time seeing any argument that Israel hasn't had effective control over Gaza since October 7th.
Thank you. Ido, do you want to quickly respond? And then I want to begin to get to some of the fairly interesting questions we've been posed.
Yeah, I won't be too long. Well, usually. My comment is that on the forced displacement or whatever you want to call it, you have to take into account the fact that Hamas modus operandi is to work within the urban area of the civilian population. So they have tunnels, they have weapons and other munitions within houses, within schools, within UNRWA, within hospitals. And yes, the outcome would be that those places would lose their civilian protection and will become military targets, military objects, in accordance to Additional Protocol 1 of the Geneva Conventions. Nature, location, purpose, or use. If those places are being used, then definitely they are legitimate targets. Now, to claim that there was no military necessity or no military purpose for the evacuation of the civilian population is a legitimate claim. But you need information to make that claim. You need military information that only the IDF has. Now, you could definitely argue that the IDF should explain. Israel should provide explanations about why they were forced to evacuate, why they were called to move in order for either for the protection or no, if it was for other purposes, other illegal purposes, that yes, Israel should explain its actions. But at no point, Human Rights Watch or any other organization, including the UN Human Rights Council Commission of Inquiry and others, have enough information to reach conclusions. And therefore, if the most you have is 50% of the information, which is the ex post facto, what happened on the ground, it means that you don't have what were the intentions of the IDF and what was the information that the IDF had at the time of the operation. You just cannot reach to any plausible legal conclusion about what happened in that area and why and whether an action was in fact illegal or not. You can make a claim. You can definitely make an argument that Israel should respond. And I've made that claim that Israel should respond. I actually also made a claim that by not acting to end the conflict and bring the hostages, all of them, back home immediately, Israel might be in violation of the right to life of the hostages and of the Israeli soldiers, just for not acting thoroughly enough or driven enough to end the conflict and save the hostages faster. So I'm not saying that Israel is perfect, not at all. I've been criticizing the Israeli and the IDF for the actions throughout the year, but I don't jump to conclusions without having the entire spectrum of evidence and information in front of me, and that's my main claim. With regard to occupation, we've had that discussion several times, and I would just say on that, I would just say on that even after a year of conflict, Israel did not have enough control to be able to release the hostages. And I mean, we've seen in the so-called ceremonies what facilities Hamas can produce within a few days. To argue that Israel have effective control over the area in October 7th or after October 7th, full control, Israel does not have full control over the area. Israel might have full control or effective control over certain areas, but even that will probably end now when we are stepping forward onwards within the ceasefire agreement, which hopefully will lead to a full ceasefire and the end of the return of all the hostages. Not so brief, but I've covered.
Thank you, Ido. And you raise a really critical point about the level of intelligence required to make the assessment as to whether or not a facility is a military target. And that's a perpetual problem in these analyses from the point of view of international humanitarian law, certainly. We've got some great questions here and very attentive attendees. I'm not going to take them in the order in which they appeared, but I will get to them all, I hope. The first question has to do with the definition of this conflict as international or non-international. And doesn't a lot depend on whether the conflict is considered an international or non-international conflict? Assuming the former, for example, how do the participants analyze the conditions upon which evacuation from occupied territory is permitted under Article 49 of the 4th 1949 Geneva Convention? Similarly, more specific analysis of what provisions apply would be appreciated. If the point is that IHL is being disregarded, the questioner asks for specific analysis of the applicable, in particular, set portions of the Geneva Conventions. So let's start with, is it an international or non-international conflict we're talking about here? Because that has considerable implications for an analysis under IHL.
I can take it if you want.
Sure, go ahead.
Well, let me be as legal as lawyer as I can be, and I would say it depends. It depends, but it's not as crucial as we might think, because generally the majority of customary international law is applicable to both international and non-international armed conflicts, and therefore, with regard to conduct of hostilities, for the majority of it, there won't be much difference between the two. It is relevant mainly to specific aspects like combatant status and combatant immunity, for example, and questions of occupation are generally considered to be within international armed conflict. Where it became more interesting or more problematic was in the decision of the International Criminal Court to classify the conflict as both international with regard to Israel versus the Gaza Strip as part of occupation, and non-international conflict between Israel and Hamas, as Hamas is a non-state actor. And the outcome was that the ICC could claim charges against Prime Minister Netanyahu and former Ministry of Defense Gallant on issues of starvation, which are not applicable to non-international conflict, and at the same time refrain from making any references to Hamas, for example, the use of human shield, which is a violation under international conflict under the Rome Statute, but not in a non-international conflict, again, under the Rome Statute. So there are specific areas in which those aspects will make a difference. When it comes to IHL, and not necessarily international criminal, but proper IHL, laws of armed conflict, for the majority of the conduct of hostilities, it is the same. And I can tell you that from what I know, from what I've read and what I've heard from them, the IDF is taking the higher threshold of they're saying, well, it might be complicated. We don't know if it is international or non-international conflict as a certain, and therefore they are claiming to take the higher standard upon themselves. And with regard to the ICC, I should just add that ALMA, the association that I'm a chairperson of, has submitted a amicus curiae to the ICC with regard to the classification of the conflict, saying that it is impractical to claim this different classification of conflict between the same two parties to the same conflict for the same act. You can have two types of conflict in the same territory, but not with regard to the actions between the same two actors. And that was our claim, which we submitted in the amicus curiae for.
Thank you, Ido. Omar, Christian, do you want to comment on the international armed conflict versus non-international armed conflict? Omar, Christian, you want to go first? Go ahead.
Yeah, all I'll say is, like, when it comes to conflict classification, I think how Ido, especially in this context, Ido said it best when it depends. It really depends on how you view the status of certain parties to this conflict when making that determination. And then, without repeating everything that he said, which I agree with a lot as a legal scholar, but I just wanted to add that regardless of how you classify it, certain customary rules still apply to both regardless. So you still have your 4 fundamental principles that are going to be important to remember, that they apply regardless of how you classify it.
Can you restate the 4 fundamental principles?
Yeah, so you'll have the principle of military necessity, principle of distinction, principle of proportionality, and principle of limiting unnecessary suffering, which others might refer to as the principle of humanity. Thank
you very much. Omar.
Yeah, just a 30-second response. I largely agree, actually, with both of the analysis. I mean, there's undeniably an international armed conflict that's the occupation, right? I mean, that is consensus, I think, by virtually everybody, sans maybe the Israeli government. And then there's an non-international armed conflict by virtue of the conflict between Palestinian armed groups and Israeli forces in the Gaza Strip. Now, there are different ways. The depends answer, I think, it makes sense because it depends how you, in part, apply and define that in the context of the Gaza Strip. But I think, clearly those two elements are there, and then how you would characterize particular actions in a particular context would depend on the facts. But I generally agree with the vast majority of what, except maybe at the very end, what Ido and Christian set up.
Thank you very much. And since Ido helpfully brought up the International Criminal Court, I want to ask the panelists about the executive order issued on February 6th by the new Trump administration imposing sanctions on the International Criminal Court. And that executive order stated that the ICC has engaged in illegitimate and baseless actions targeting America and our close ally Israel. The ICC has, without a legitimate basis, asserted jurisdiction over personnel in the U.S. and certain of its allies. So and the executive order points out that neither Israel nor the U.S. is a party to the Rome Statute or a member of the ICC. How would you criticize or not the legal argumentation, at least, of that executive order? In other words, the ICC's actions and pronouncements should not apply to non-signatories.
I can start, Marianne, because this is really straightforward, and it kind of exposes the double standards here because, I mean, nobody's making the argument about Russia and Putin, who have been indicted by the ICC on the very same logic, right? For those who are not familiar with the International Criminal Court, they have jurisdiction on the territory of a state party. And just as Ukraine was a state party, and therefore jurisdiction was granted when Russia committed crimes in Ukraine, the state of Palestine is a state party, and when the Israeli forces commit abuses in that occupied Palestinian territory, there is jurisdiction there. And the court has also said, and the prosecutor has said, that October 7th would come under the court's jurisdiction by virtue of the fact that the crimes were organized and the perpetrators came from the occupied Palestinian territory. Now, just to be clear, this is not just an opinion by a human rights organization or even the prosecutor. The former prosecutor of the ICC actually went to the court before moving forward with the formal probe to see whether Palestine was sufficiently a state for the purpose of ICC jurisdiction, right? And the court in a 2-1 decision upheld. Now that could be challenged later on during the process, but the logic here, the legal logic, is the same one that's been used, in the case of Russia and Ukraine. I think quite simply the executive order. I have no other way to put it. It's the United States siding with war criminals at the expense of victims of grave abuse seeking justice, right? Sanctions should be for, people who commit abuses, not those that are trying to prosecute them. So I think the good thing we've seen is a number of states rally, there was a joint statement by 79 states rallying around the court and the independence of the prosecutor. I think these are really basic, principles here. And I think the arguments here simply, don't hold water. And you know that by seeing the ways in which they've been applied in other contexts. The International Criminal Court is critical. It's a last venue for justice to victims of atrocity crimes. And it's, a critical role when national authorities are unwilling or unable to conduct genuine proceedings. And that's absolutely the case in Israel-Palestine, as Human Rights Watch, as B'Tselem, as Amnesty, as numerous human rights organizations have documented. Again, this is not a one-sided investigation. There were charges brought against leading Hamas officials also for October 7th. Those individuals have been killed. So, what remains are the charges, of course, against Gallant and Netanyahu. But this executive order, quite simply, is the United States choosing an ally over defense of the rules-based international order.
Ido, did you want to add to that at all?
Yeah, I want to add a bit of a different perspective. The Rome Statute is a treaty, right? And we are basically talking about a treaty law that establishes an organization called the International Criminal Court. Now, under the Vienna Convention on the Laws of Treaties, Article 34, which is probably the only article I know by heart from that treaty and from most of the treaties, a treaty cannot impose obligations on a third state. The definition of a third state is a state that is not party to the treaty or the convention. And to argue that the ICC has any jurisdiction over a non-member state is simply false. International law doesn't work that way. International law cannot place obligations towards states that are not party to the treaty, regardless of what the treaty say. Or says, regardless of what is the wording of the treaty, right? That's the fundamental basics of laws of treaty. Now, to claim that those states, when they are being charged and by the institution that was established by a treaty which they did not give jurisdiction to, should just roll over and say, yeah, we agree, you have jurisdiction over the prime minister, over the president, etc. This is not how international law and international relations work. I mean, when states have the jurisdiction being harmed, they operate against it. So I think we have to accept the fact that non-member states will not stay quiet when in an organization that was established by a treaty, the International Criminal Court, and the prosecutor and the judges, which are very prominent and respectful judges. I have nothing against them as judges. I'm just saying that they don't have jurisdiction over the Prime Minister of Israel because Israel is not a state party. Now, when it comes to non-state parties, we're talking about states that did not agree to have the immunity of head of states revoked under the Rome Statute. And therefore, we have some kind of clash of rights between the obligation of a member state towards the court and the customary norm of heads of state immunity. And France just said it recently that there is a question about whether or not if Prime Minister Netanyahu would enter France, which obligation has a higher norm. And the fact that the judges of the International Criminal Court have conclude that they have jurisdiction, I have to say that, I mean, ever since, I mean, let's go US, Marbury versus, I forgot the name of
Madison.
Madison. Courts have the tendency to acknowledge that they have jurisdiction when that question comes into play. We've seen it in Marbury, we've seen it all over the world. It's part of jurisdiction aspect. When there is a question of whether or not basic jurisdiction exists, courts have the tendency to say, yes, we have jurisdiction. They might rule later on that otherwise in the decision, but first and foremost, they will decide to hear the case and analyze it. And it's the same here. And I'm not going to repeat what I've said in the previous session about the question of the effectiveness of operating, pointless arrest warrants that will never be implemented. And by the way, I've said it I was asked back then what I'm saying about Putin. I've said the same thing about Putin. Putin will not get to The Hague, and therefore the entire process against Russia is pointless. I'm saying that the ICC should focus on member states and states that have agreed to provide its jurisdiction, or states that situations that have been provided situations throughout the Security Council, which can override all those little aspects that I've mentioned. But at the end of the day, I'm not sure that I agree with the executive order, with Trump's executive order and how broad it is. But I'm saying that we have to acknowledge that non-member states will act against the jurisdiction of the court when they are being pushed and their interests are being pushed off.
Thank you, Ido. There are a couple of questions. I'm turning back to the questions in the chat. There are a couple of questions regarding what can amount to perhaps a catch-22 about Israel providing basic essential services such as electricity and water to Gaza, or any country in conflict with another that provides essential services that keep civilians alive. Of course, in providing those essential services, that can turn the country into an occupying power with different obligations, right? So how would you comment on the provision of basic essential services required to keep civilians alive, and what that means for the country providing them if there's a conflict there?
Yeah, I can start with this. I mean, Marian, look, people forget that Israel actually gets the majority of its water from the occupied Palestinian territories, and there's a whole bunch of legal issues around that. But again, part of the reason why we say Israel is the occupying power is that it controls between the area between the Jordan River and the Mediterranean Sea, the natural resources, the extrication of that. Obviously, also had a process, but it was very much tilted in favor of the Israeli government, but it's not doing this out of the goodness of its heart. I mean, it is an effective control over these areas, and including the resources that are there. And by virtue of that control, they have a duty to the occupied population to provide for the welfare, including to provide access to these services. So, I've actually been very insistent in Human Rights Watch publications that if Israel is not going to provide this, they at least need to be able to not impair and allow the local authorities and other actors to do so, even though the obligation is to provide, but it can be done if it facilitates others. But obviously, when it comes to, for example, now, restoring health services or water, the Israeli government is actively impeding that with its policy restricting things from coming in, with its policy around humanitarian aid. But basically, it's very clear that this is an obligation of the Israeli government. And again, they're extracting the resources there. If it's okay, I want to say a quick word just on immunity. And the point I want to make is it just shows the ICC judges have made very clear in relation to Putin's travel. Article 27 of the ICC treaty rules out immunity for heads of state and government officials, and you can't cherry the law can't be cherry picked. Ido makes a point about about treaty law that's distinct. So I'm not trying to characterize his argument, but I want to be clear that to date, no international hybrid tribunal that provides for individual criminal liability for serious crimes allows such immunity. We're not talking about sort of run-of-the-mill violations, right? The charges against the Netanyahu is wanted for atrocity crimes, right? Crimes against humanity. And take your pick of Nuremberg tribunal, ad hoc tribunals, all of them, allow, say, official capacity is irrelevant for the purpose of investigating, those treaties. So I think it's very important to understand the gravity of these charges. We're talking about, very, very serious atrocity crimes.
Thank you, Omar. Other comments? Okay. I'm going to return to another question has been raised, since I think I was the one who referenced Ukraine, about the distinctions to be made between the Ukraine-Russia conflict and the Israel-Gaza conflict in terms of international humanitarian law. How are these two conflicts different with respect to the application of international humanitarian law?
I mean, I'll just keep mine very brief, and then if anybody wants to add to it, I think it stems to the debate when it comes to conflict classification and what the conflict actually is. I don't think I think there's a large majority viewpoint that the Russia and Ukraine conflict is a clear-cut international armed conflict, and then when you go into the Israel situation, Israel-Gaza, there's more of a debate there.
Other comments on that?
Yeah, I will second that and say that with regard to the applicability of international humanitarian law, both situations are on conflict, and therefore international humanitarian law applies. Question of classification, as I said before, to some extent are relevant. I will answer also a relevant question. Someone asked me about the 1977 additional protocol. Well, Israel is not party to the first additional protocol. Israel is actually even a persistent objectors to some aspects of that protocol, but other than those 2-3 provisions that Israel objects, Israel's formal position is that the conduct of hostility aspects, let's say like that, of additional protocol 1 reflect customary international humanitarian law and therefore applicable regardless of whether or not Israel is party to that protocol or not. And actually, it has been repeatedly publicly said and formally said in Israel's reports and submissions to either fact-finding reports, etc. Israel consider several and most of the additional protocol provisions as reflecting customary international humanitarian law, and therefore they are considered applicable regardless of Israel's status of the protocol.
Anything else on that?
I just wanted to strengthen what Ido just said. I mean, what he said about the viewpoint of additional protocol 1, it's the same viewpoint that a lot of countries have that didn't ratify it, that there's plenty of provisions of it that are customary law. And there's a few provisions that because of those provisions, it was the reason behind not ratifying it. So it's not just Israel's viewpoint, it's the United States, it's lots of other countries that did not ratify it. That was their reasoning for doing it, was the stuff we agree with is customary law. We're not signing on to it because of these provisions, et cetera.
Your responses to that. Oh, I'm sorry, Omar.
I was going to give a 15-second response. So we apply the same standards in Ukraine when it comes to armed conflict, the Russian occupation of Ukrainian territory, as we do in the occupied Palestinian territory.
All of your responses sort of raised the question about the force of the International Criminal Court in terms of, and certainly the executive order also raises that question. Given that the International Criminal Court an effective enforcer of international humanitarian law? I'll put it in very broad terms, in your views right now.
I mean, I can start, Marianne. Look, I mean, I think we can have a nuanced discussion, and there's been the legal literature, people do human rights is littered with that. I worked with when I was at Stanford Law School. Sherry did as well with Professor James Caballero, who's written a strong argument for the power of regional human rights mechanisms, and that they're a more effective resource at dealing with human rights issues than the ICC, right? The ICC having obviously a very big, budget, but, obviously these are very complicated proceedings, and it can resource intensive, and you don't always get, even in the case of Libya. I mean, we all saw what happened, with with Italy, and having somebody wanted by the ICC whose return was facilitated to Libya instead of being sent to the ICC for prosecution. So, but at the same time, the world needs a court like this. That's a last resort. I can tell you firsthand from interviewing Israeli and Palestinian victims of grave abuses that, when there is impunity, and I've worked in Egypt, I've worked in many contexts around the world where there is systematic impunity, that can really be a free license for escalation of abuse. I wrote the report on the mass killings of protesters in Egypt, in the Rabaa massacre. And I remember I was forced off the ground in Egypt. We warned, if there was no accountability for this massacre, it's going to be a green light for the regime to continue to go after dissidents. Here we are more than a decade later, and you see tens of thousands of political prisoners, rampant systematic torture. So, having that, and we know in Israel-Palestine, I mean, you can remember, and Ido might be able to help me with, who said, I think it was a former Israeli foreign minister, who directly came out and said that Khan al-Ahmar, a Palestinian community in the occupied West Bank, is still standing today because Israeli officials were afraid, they were deterred by the prospect of an ICC action in that particular instance, because there was very clear warning issued by the court if they were to demolish that Palestinian community, I think about 1,000 residents. So we can criticize it, the efficiency. There are reasons for it. Everybody has a right to a fair defense, by the way, including Netanyahu and Gallant, to make all the arguments legal and factual they want to. But it's slow, but I think it's a huge progress that we have this bulwark there. And by the way, if it's only exists, if we don't go after allies of the West, if the court doesn't do that, then if you allow double standard, it's not an effective body. And that's part of, and I've said this in a previous panel, so I won't repeat it, part of the power of South Africa's genocide case at the ICJ, part of the power of these indictments is it's showing the world, right, that justice is impartial and that the same standards apply to everybody. And last thing I'll say is, we've been pushing for accountability in Ukraine for Russian abuses. My colleagues engage every day with South Africa's and countries in the global South and in the Arab world and the Islamic world. And they all come back to us. No, I don't want to, many of them have come back to us and say, how can you push us on this when clearly the world is choosing its partnership with Israel over applying the same standards in the Israel-Palestine context? So this, to me, is about the very credibility of the system. If the rules don't apply to everybody, they don't apply to anybody.
Thank you, Omar. Other comments on that? Ido?
Yeah, just I want to say briefly, but I have a reputation by now. I think that I agree with Omar that justice should not be only to third world states, and Western states should also be accountable. But at the same time, it should be reflect to those states that actually have agreed to be under the jurisdiction of the court. That should be the actual framework of jurisdiction of the court. I do agree to that to a certain level. The ICC has affected the way different states and different parties do operate on the field. And within the Israeli discussion, international lawyers, self-included, have kept claiming from day one of the conflict that Israel must follow IHL. And in the first days of the armed conflict, it was much more complicated than today. And Omar has referred to several statements that were made in October and maybe also in November by Israeli officials. And we have to look at those statements within the context that were and the mental context and the emotional context that Israel has been to at that point of time. But even within that framework, local international experts have claimed that we must operate in accordance to IHL. We worked with legal experts and military commanders and state officials in order to ensure that they remember, remember isn't a bad word, that they are aware of the fact that IHL is applicable and they must operate in accordance to IHL, and reminded them that Palestine has ratified and joined the ICC, and therefore there might be further international pressure over violations of IHL. At the same time, the question remains the same: whether or not Israel should be under the jurisdiction is one thing. The fact that the ICC had some provisional impact on the players on the ground, I completely agree. It has some effect.
Thank you. So I'm going to give a preview of coming attractions by asking our panelists to comment on the application of international humanitarian law in the cybersphere, given that there's been a lot of recent work on this, and we've got the head of the Liber Society, Sherry Krebs, professor in Australia, will be conducting at the American Society of International Law a separate panel discussion of AI and international humanitarian law issues for those of you who are in Washington or wish to attend. But just briefly, how clumsy is the current application of international humanitarian law in the cybersphere? Does it lend itself to being applied? Do the tried and true principles we think of as connected with the Geneva Conventions, can they be applied in the cybersphere? Don't all rush in at once, please go ahead.
Well, I'll go back to being a lawyer and say depends. It really is a question of what provisions and what implications are we talking about. If you're talking about armed attack is usually expected to have some kinetic effect. And therefore, if we're talking about a cyber attack that actually leads to a kinetic effect, then definitely we have IHL relevancy to armed attack, etc. Distinction, precautions, proportionality, everything we need to take into account. At the same time, we also have questions of a more vague situation of whether or not what are we doing with information on the cloud? What happens? How can we distinguish between military information, military intelligence, or military, even maps and other kind of data, and civilian information, civilian data? How can we make the distinction and ensure that civilian is protected while military is allowed to be attacked or to a certain aspect? There are also the question of should we distinguish between what happens in the real world versus what happens in the virtual world? And in an old paper, I think that I've yet to publish, let's say like that. An old paper that I will publish, I've mentioned that I do like what I refer to as the James Bond test. If James Bond was able to do it physically, then this is not cyber unique. And therefore, we should apply the same rules of IHL to that cyber situation. And that means that if I could go into your office and steal a map or steal some intelligence from your office, the fact that I can do it right now through virtual aspects doesn't make a change with regard to my activity. What I cannot do, one of the biggest differences is the magnitude. I can get all of your intelligence at once, for example, with a good hacking operation. I can do a denial of service attacks that will prevent you from operating some kind of defensive mechanism. But at the end of the day, it really depends on the situation that we are talking about. It really depends on the mechanics of what we are trying to operate. But as long as we are talking about what could be referred to as an armed attack, even if it starts via the cyber realm, if it ends up with an armed attack, physical, kinetic armed attack, IHL applies completely.
Thank you, Ido. Omar.
Yeah, I mean, I would say obviously, yeah, digital tools are not military weapons. However, their use in military operations subjects them to the restrictions of IHL. I think that's similar to what Ido said, but I wanted to word it in that way. I mean, as the ICRC has noted, any new technology of warfare must be used. Any new technology of warfare must be used and must be capable of being used in compliance with the existing rules of IHL. So I think the two most relevant rules when it comes to the tools, and again, there's been a lot of reporting about these tools. I won't go into where is daddy, lavender, gospel. I mean, there's a lot of articles folks can read about that based on mostly on sources in the Israeli army that have spoken to Israeli journalists. Obviously distinction, that attacking forces distinguish between military objects and civilian objects, and only attack the former. And if you're relying on AI and machine learning without human intervention, that raises really significant concerns about the degree of scrutiny that's and then even the proportionality assessments, and that's there that whether or not that's actually not to say that human operation, and there have been very serious challenges that we and others have raised around the Israeli government's attacks based on decisions around proportionality and distinction. The second relevant rule is taking all feasible precautions to minimize incidental loss of civilian life and damage to civilian objects. And again, if you're relying on AI and machine learning, and we've documented this, we put out a report, I'll put it in the chat, about faulty data, inexact approximations that have informed military actions in ways that could contravene IHL in the precaution and distinction rules. There's also privacy issues, and I mean, Ido, raises some points on that. We have actually documented, and again, I'm happy to share. I'll share the link to this, but we actually found by accident that the Israeli army had erroneously put online, based on the source code of their evacuation system. This was part of the research we did, what appears to be operational data related to the monitoring and evacuation of people. So we were able to actually see names of families and all the Israeli info. We found it based on the source code, right? So others can find it as well. But it again goes to show that human rights law here also, is relevant, including, the right to privacy. And again, if you're using machine learning to label somebody a terrorist, and that could be the basis for arrest or lethal attack, you might not meet the evidentiary requirements of criminal wrongdoing that the law requires, right? Like, would it survive a court, based on the algorithm that you did? So anyways, I could go on and on and on. I'll put in the link, both our a report that we did on these issues, but also we did a Q&A that both sets out some factual and legal issues for this. We did this in the fall, so I'll put that in the chat.
Thank you very much, Omar. And I'd like to point out to everybody that Omar has posted some links in the chat function to answer questions that have been raised. So please take a look at that. Christian, did you want to add anything?
No, I was going to say, I don't think it's debated that IHL applies to the topics that we're talking about. I think that's a well agreed upon fact. Some things that are definitely different because of when it comes to cyber, especially, are long. You have to look forward a lot more in a proportionality assessment. It's not just going to be as immediate as it would just be an everyday type of kinetic attack on the ground. Like, the consequences could be much more severe, and they could linger, and they can spread much further than just a missile strike on an isolated area. So you have to consider that stuff as well.
Thank you. So I'm going to ask the panelists to offer some concluding remarks. And in your concluding remarks, if you choose to, you can reflect on whether or not the stature of international humanitarian law generally has suffered a diminution over the last few years, or not. Omar, why don't we start with you since you began?
Yeah, we didn't get to talk about, which I actually is refreshing, because I kind of agree with Ido that it's probably, it's not going to happen. But I mean, Trump's comments, I think, to me, bring a lot of these issues, to light, because he's directly, advocating for ethnic cleansing, right? I mean, removing 2 million people, from the land that they live. And again, the majority of these people are refugees who have been denied their right to return to the homes that they were displaced from in 1948. And again, IHL prevents forced displacement, permanent forced displacement. If it's carried out with criminal intent, it's a war crime. If it's part of if it's state policy, a widespread systematic attack, it's a crime against humanity. And that's exactly what Trump is laying out here. And we're precisely here because of the impunity, and because the previous administration continued to arm, the Biden administration continued to arm the Israeli government despite the mounting evidence. We also evidence of war crimes and what U.S. weapons being used for them. We actually put out a report 2 weeks ago that said the U.S. is complicit in the unlawful use of U.S. weapons in Israel. I mean, it's on notice, and we documented the relevant legal standards and tests for why the United States under Biden was complicit, and we issued a warning to the Trump administration about further complicity in these particular actions. So, Marianne, to your question, and I know I've ended this probably every one of my remarks by just talking about why this matters beyond Israel-Palestine, but I'll say it again because we're talking here about the very institutions that are charged with protecting civilians in armed conflict around the world. The International Court of Justice has issued binding provisional measures in the genocide case. They've issued we didn't talk about, I'm sorry if I missed I was on leave during the previous, if you talked about the advisory opinion it released on the occupation, really important findings and language. It's an advisory opinion, it's not binding, but still the highest court in the land set out very important legal principles that should be followed. The International Criminal Court has issued binding arrest warrants. UN bodies, binding on member states, but they've issued arrest warrants. And you have, of course, the restrictions on the UN and UN entities, UNRWA being the main one on the ground. This is a full frontal attack, on the international rules-based order. And, I think that the world's response has so far, I think, been insufficient, frankly, to stop this. And I really worry about the implications for international law and for these institutions going forward. I think in some ways being in this Biden Trump administration, the risks have increased, right, about the threats. But on the other hand, it should provide a clarity for those of us. I mean, Ido and I have, respectfully disagreed on many substantive points, but I think we both agree on the legality of Trump's plan, right? So I think, if we can try as lawyers, as people concerned with the law and ensuring that it's not just words on paper, but actually has meaning. I think we need to use this moment to defend the rules-based international order in these institutions, even if we disagree. I mean, we've said this about, you might disagree on genocide, but if the court issues binding measures that are ignored, it undermines that court's ability in all situations around the world. So I think we need to be consistent, and this is a moment to really rally around and defend these institutions, because if the sanctions are allowed here because an ally is being shielded, we have no basis to push back when Russia does the same, when China does the same. So I think this is really a moment of challenge, but also a chance to really rally together around the principles we believe in. If we can defend it in this current moment, I think it gives us a chance to come together.
Thank you, Omar. Christian.
Yeah, I think Omar's his closing portion was exactly what I wanted to emphasize in mine, which is really that I find hope in that IHLs not be diminished because of conversations like this. Like, I feel like their disagreements are natural in law; they're supposed to happen. But at the same time, throughout this entire conversation, there have been areas where every one of us was in total agreement on certain standards of conduct or understanding of the law. And that matters because IHL isn't just a debate. It impacts people on a daily basis. But this just demonstrates that we find importance in it, and a lot of other people do too. And as long as there is that feeling of importance about IHL, it will continue to exist, and it will continue to provide the protections that it needs to do in warfare.
Thank you very much, Christian. Ido.
Yeah, thank you. I said at the beginning, or at the end of my introductory comment, I said that we're at the cross point of international law. And I think that everything that we've discussed here provides some demonstration or a glimpse of that cross point. I think that international humanitarian law right now, and generally international law and even international criminal law, are at the risk of being used for political purposes or for the diplomatic purposes or whatever you want to call it. And when people are quoting international humanitarian law provisions and violations and jumping to conclusions that there are violations of international humanitarian law in order to justify what they think of the situation, regardless of what the facts on the ground actually show. And I don't necessarily claim that on Human Rights Watch at that point, because they are actually trying to prove and show demonstration and show actual situation. But definitely, for example, the cry genocide has been shouted very strongly, very early, without any relevant legal proof by legal experts. And I think that this kind of misuse of international humanitarian law and international law by legal experts, by diplomatics, by human rights advocates and activists, etc., is a key point of risk to international humanitarian law, because international humanitarian law should govern the laws of hostilities, the conduct of hostilities in our conflict, occupation, etc. But when we are misusing international humanitarian law in order to justify our point of view, then we are in a very risky situation. And I think I've said before in previous sessions that I find it very hard to see when people actually say, well, that point is actually against what I believe. So people usually believe that Israel is violating international humanitarian law and then go and justify it through the provisions of the law. And vice versa. People think that Israel follows IHL and therefore grow and show that IHL is being fulfilled to the letter. And I think that as long as IHL and international law are being misused for agenda-based arguments, then we are at the risk of the destruction of IHL and its implication on the ground, because it will follow down from the commanders and from the politicians to the soldiers on the ground, and that would be very, very dangerous situation. And I will take advantage of being the last speaker in the concluding to thank you again, Marianne, for organizing this event and this series of events, and to plead again that one day we will be able to do it in person and not just on a webinar. Thank you very much.
Thank you, Ido. Thank you, Omar Shakir, Christian Jorgensen, and Ido Rosenzweig, and Taylor Kirkpatrick and James Steiner of the American Society of International Law. Once again, a very robust and informative discussion. We look forward to the 8th in this series, sometime in late April, early May. Everybody take care, and thanks to the attendees for great questions. Thanks.